Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on Section 50 of the Ndps Act 1985. Section 50, that is search of a personal search of a person suspected to be in possession of the so-called narcotic drug or psychotropic substances. According to Section 50, the bold rule says that if any such has to be conducted, then the arrestee, that is the police officer or the officer effecting the arrest, he has to inform the detainee or the arrested person that this arrested person has got a right. Please remember, right to be searched before a gazetted officer, right to be searched before a magistrate. The police have to inform them their right. The next step is, if they are not willing, the police officer can himself conduct a search of the person. But right to be informed, this is more important. If this is not followed, of course, if it is followed on paper, then it's okay. Otherwise, definitely the case will end in acquittal. The concerned officer will be given the so-called strictures. That means for the perfunctory investigation. Of course, these words may be sounding different for you. It will be easily understood by the police officers. What is a perfunctory investigation? What is investigation? Investigation means collection of evidence. If they do not do it properly, if there is any lapse, then it is called perfunctory investigation. So for this strictures, that is some remarks can be passed against them. There are so many occasions where the courts pass strictures. Of course, nowadays it's not happening. Previously, the courts are very serious regarding the investigation. ADJ Ungol, there was only one ADJ at that particular point of time, maybe in the year 84 or 85. The ADJ said, the police will not entrust investigation of murder cases. So this type of police officer who has created stories, who is a very good story writer, let him go to the film field, cine field and show his intelligence there. Like that he has passed strictures. Of course, the SP has given a memo and later it was dropped also. It's a different thing. So like that you may get strictures also. So without wasting much of time, let us go into the case proper case. This case is, Mina Pen versus State of Uttar Pradesh. Criminal Appeal number 3167 by 2023, decided on 22nd August 2023 by Honorable Justices Abhay S. Voka and Pankaj Mittal. Right? They held that if the accused were not informed of the right to be searched by the magistrate or the right to be searched by the gazetted officer, it is a violation of the safeguard under Section 50 of the Ndps Act 1985. This is a protection. This is a safeguard given to the accused person that the arrest should be conducted or the search should be held in the presence of the so-called gazetted officer or the so-called magistrate. Why? Because it will give a sanctity. Otherwise, what happens? Everybody, we know that the police will put some ganja in the pocket of the person whom he doesn't like and involve him in a case of ganja. Ndps Act finished. No bail. He has to be in jail for about 1 month or so. So there is a safeguard. This safeguard must be right. Normally, do you think that the police do not know this safeguard? Yes, we know. We have to write. So we used to write in the Mahazarnama or Panchnama that even though we have told him that he has got a right to be searched before so and so, he opted or he volunteered that the search can be done by the police, therefore we conducted the search. But what happened is, in this particular case, please remember, that's why I have been telling, every case depends on the facts and circumstances. In this case, the evidence of the witness PW4, that is the investigating officer, Mr. Sanjay Singh, he is a police officer. He admitted that a consent letter was already prepared on which the signatures of the accused or the appellant were taken. Finish. So that means, my dear police officer, yes, you can conduct the search like that, they have written. But even in that letter also, the consent was not mentioned. The letter also does not say, I am willing to be searched by you, and you have informed me my right to be searched by the gazetted officer or the executive magistrate. It's not written. The consent letter, which is signed by the accused, doesn't show that the accused was not informed. The accused was informed or not about them. So there is no indication that the right to be searched before a magistrate was not mentioned even in the consent letter also. And the FIR did not disclose that about the consent, and the GD entry also does not give any information regarding the consent. So when the recovery was done, doubt time at about 12 noon. So definitely at that time you can take him to the magistrate, or you can take him to the nearest so-called gazetted officer. So please remember, of course, on behalf of the state, the PP will be there. He says, consent letter says, please remember, this letter says, the applicant has voluntarily agreed search by the police officer. Is an indication, Your Honor. Of course, the letter, the particular words may not be there, but the Honorable Supreme Court of India relied on the very famous decision, that is Vijay Singh Jadeja versus State of Gujarat, 2011. Therefore, the right has to be explained to him. It is a caveat, it is a protective safeguard to the accused person. That right has to be explained to him. Of course, even then, if he says, yes, you can search me, the search can be conducted. Otherwise, it is illegal, it is void, and therefore the appeal is allowed and case is acquitted. So please read the judgment and enrich your legal knowledge. Thank you.